thank you very much for the invitation to speak here. I've enjoyed so far the substantive topics of discussion and also the interaction, and I hope I can add to that. The second thing I must say is that I have also, I think following on from Stephen Ballantyne's point, I also have been something set off by the air conditioning and also by flooding my room yesterday whilst trying to take a bath and send emails at the same time. So if I do break out into hiccups, coughing, I apologise. Also, if there's any leaks, that could be caused by the damage I caused to my room yesterday, for which no admission of liability is given. I'll see them in court. I hope you'll represent me before the local tribunal for a rational fee. I think this follows on rather nicely. What I'm going to say follows on rather nicely from the last session, where Mark made the point that the dispute resolution clause is put into a contract all too often without a great deal of thought. And I remember talking to someone and asking, why did you put this clause in this document, leaving out the words "you moron," which probably deserved to be in there. And the person had said that he had simply cut and pasted the section that said, when I say he, I mean she, and everything. And it had this nice jurisdiction clause after it. So he'd taken that also from PLC. I didn't hit him, I wanted to. I think that in those circumstances, this is probably, it's easier to cover up the crime. But that's the worst example I've heard, and that person has since found exciting new opportunities away from our firm, actually, coincidentally. But it comes to a big point. You put the jurisdiction clause in an agreement without necessarily... Well, we're all disputes lawyers to a greater or lesser extent, but we're not the people who draft the documents. And it's like that split between public health doctors and the people who actually treat you. We're picking up pieces. We talk about what... Sorry. Very sorry. We talk about what should happen and the advantages of this at seminars such as this, but we don't actually put them in. And so the first thing I would say is really we should be bringing everything that's happened so far, we should actually do for our corporate non-contentious colleagues. They're the people who really need to know to come to see us before it's time to put the clause in. With that caveat, the next point is the views that we get. I think too many people's views of litigation, it comes from a sort of a bleak house, Jarndyce and Jarndyce view of litigation, where some old man, always an old man in a wig to cover up his baldness, will keep talking about how more disclosure is needed, versus what I always call the Queen Mary view of arbitration. And my apologies to our colleague who did cite the Queen Mary study, where arbitration is full of fresh-faced young people, all particularly keen to resolve a dispute at lowest cost. That doesn't fit any arbitration I've ever been involved with. Obviously, when it becomes clear that one person is trying to is looking at losing any dispute, we get gamesmanship, at the very least, and possibly we get, again, the unreasonable behaviour of people who start a claim, do the minimum, and bring it forwards. Now, the first point I'd make is that in arbitration, arbitrators are too unwilling, in my view, to pull down the guillotine on unreasonable people, bad behaviour, chances. They are just not. There's a cultural, I think, unwillingness amongst them to, even if they have the power to do so, they just won't, to bring down a guillotine and say time periods matter. We're always looking at more extensions, whereas a court will tend to say, you've had your chance, you've had your extensions, off you go. The next is flexibility of procedure is something that's always said to be an advantage of arbitration, and it is there in principle. You can choose your tribunal, choose your procedure, and at least in theory, tailor-make the dispute resolution procedure to the dispute. In practice, again, almost every arbitration I've been involved with under LCIA, ICC, or Swiss rules has ended up with either one or three law firm partners, QCs, retired judges being on the panel. The IBA rules almost invariably being adopted on evidence and disclosure, then 2 rounds of witness statements and 3 rounds of written submissions, followed by a hearing, followed by some final written submissions. And it's as if in arbitration the flexibility exists, but people are just not willing to accept it. And if you do turn up to a hearing and say, no, can we do it differently, please? You tend to find yourself really, you lick your finger and feel the wind blowing, and it's not blowing in your favour. I do think in the English High Court, and in the DIFC Court, and in the BVI courts, you definitely get more a recognition of the fact that case management directions have to be bespoke. That, ironically, I've had great experience in getting English judges recently not to order standard disclosure, or to order standard disclosure only on very limited topics. The BVI courts have again been very willing to limit disclosure but focus it. I always find with disclosure you either have too much or too little. You're disclosing back emails that people have sent to each other, but the few documents that really go to the crux of the matter, you never seem to get all of them. It is easier now to get with the English High Court and certainly the BVI High Court to focus the disclosure order on what you're looking for, on those few paragraphs in the pleadings, and just to allow everything else to be either no disclosure or disclose the documents on which you intend to rely. There's also the issue of appellate review. Now, I know there are now appellate procedures that are sort of being experimented with in arbitrations, but arbitration specialists always set out the limited appellate review, the fact that it's final, as being an advantage of arbitration and saying it's a speedy procedure. But when you are taking 2 to 3 years to get through something, I always think it's a good idea to know that maybe it isn't the end of the line. If you are having something akin to an English construction industry adjudication or to a small claims hearing, limited appellate review is probably quite a good idea. It just focuses the mind. When dealing with a typical large-scale commercial arbitration, I am less sure, and you end up with a situation where you either have to upset the whole apple cart on a jurisdiction challenge, or let bad single decisions go through. Again, with litigation in the commercial court in London, the commercial court in the BVI or in the DIFC, individual judgments can be appealed on a case management basis. Whilst that does add to the time and cost initially, by getting it right and focusing issues, it can cut down on the cost going forwards. There's also the publicity issue. Now, I know what Stephen said about how in the Dubai, the civil courts are private, and that's obviously the case with some civil law jurisdictions outside here. But generally speaking, litigation is public. Now, that's always, the privacy of arbitration is always said to be an advantage, but if you're going to be disputing the use of the formula for Coca-Cola or some algorithms, obviously there are good reasons to keep that behind closed doors, though most legal systems would probably allow that. On the other hand, if you are going to be cross-examining witnesses who you think are lying, or if you're having to drag documents out of people you think are concealing them, the public forum can actually be quite an advantage. People do not want to be recorded as liars or document shredders in public. I mean, Arthur Andersen, Enron, no one wants to be known as the new Arthur Andersen. There is something to be said for doing it in public, because if you're making the other side wash their dirty laundry in public, they may have second thoughts about creating dirty laundry in the first place. They may even decide to tell the truth, the whole truth, and most of the truth. Why we end up, though, is with enforcement. We had talks yesterday about how, whilst in theory you may be able to enforce foreign judgments in GCC countries, in practice there's always a reason why you can't. I mean, the use of the DIFC and analogous courts as a conduit jurisdiction where you take your English or American judgment into the DIFC, take your DIFC judgment into Dubai, take your Dubai judgment, off to Kuwait. We're seeing how that works. I mean, I know Natasha will say that this is possible. It certainly is possible. Just how far we're going to get with that, we don't really know. Whereas outside Saudi Arabia, enforcing an arbitral award in GCC countries is usually possible. At least it's more than theoretically possible. And again, if dealing with Russia or Ukraine, which I have a lot of experience dealing with, a Russian lawyer once rang me up saying he had enforced an English court judgment in Russia, and he was 40, and this was the first time he'd done it. He wouldn't, enforcement of foreign arbitral awards in Russia or Ukraine is, again, it does happen. The issue is, where are you looking at enforcing? If the other side's assets are in a common law country, then enforcing a foreign judgment in that country might be quite easy. But if it is in Russia or GCC country, you do need to, obviously, in those circumstances, essentially the enforcement tail is going to wag the rest of the dispute resolution dog. So on that point, I will hand over.